webinar in our Life After Furlough series by the employment team at Wilkin Chapman Solicitors. It's good to see so many of you joining the webinar. For those of you that don't know, I'm Teresa Thomas and I'm the Head of Employment at the firm, and I'm joined today by my co-panelist partner, Oliver Tasker. Hopefully many of you will be familiar with Oliver from the previous webinar. Since our last webinar, quite a lot has happened. Flexible furlough obviously is now in full swing. Many of our clients, and indeed ourselves, have taken advantage of the scheme. We haven't got any specific figures yet from the government because obviously we're still in the first month of the scheme, but the government would say that the job retention scheme has protected 9.3 million jobs, with employers claiming more than £25.5 billion to support wages. But despite this, unemployment is anticipated to soar, unfortunately. The predictions are that almost to 15% of the working population in the UK, if we experience a second wave. The Organisation for Economic Cooperation and Development has said that if a second wave is avoided, it's estimated by the end of 2020 that the unemployment rate in the UK will still rise to approximately 11.7%, which is the highest it's been since 1984. The current unemployment rate for specific figures is at the end of May at 3.9%. So we are going to see or anticipate seeing a rocket with those statistics, unfortunately. As you know, the Prime Minister is encouraging all of us to bring staff back into the workplace with this announcement that from the 1st of August, the government guidance on working from home, if you can, is changing. So if it's more productive and better for your employees to be into the workplace in a safe way, then obviously this can occur subject to consultation with your employees. The government further are seeking to incentivise you all not to make your employees redundant, with the Chancellor's announcement about the Coronavirus Job Retention Scheme January bonus of £1,000 per employee. So we're expecting a bit more detail about that in the coming days, but what we do know is the employee has to have been on furlough. They still have to be in your employment as at the 31st of January, and between the end of the furlough scheme and January, they have to have been paid the minimum of an average of the lower earnings limit per month. I'm not sure whether that bonus is really going to make businesses keep employees employed. So today, Oliver and I are going to take you through what you need to know if you unfortunately need to reorganise your business and propose to make redundancies. After Oliver and I have gone through the key questions in this area, I'm going to go over to you to ask us any questions that you want to. So if you look on, I can see a number of you are still thinking that you will be increasing your employees, so that's good news. The results are 49% of you think they're going to stay the same, and 49 decrease by making redundancies, which is why you're on the call. One question that we get asked a lot is, can we make furloughed employees redundant? So over to you, Oliver, to deal with that question, please.
We do get asked that a lot. Can you hear me okay to start off with?
I can, yes.
Yeah, good. Okay, just checking. So yeah, we do get asked that question a lot, and the short answer is yes, you can make those that are furloughed redundant. So we know that the idea of the job retention scheme is to keep people in employment, but the guidance very much states that yes, those on furlough can be included in a redundancy situation. One area that may potentially be challenged is, well, actually, is it reasonable to make employees redundant while the job retention scheme is still in place up until the end of October? And the advice that we really give to clients is to include within the business case on why you're justifying the redundancy situation is why you cannot wait until the end of that period. And you're not expected to as a business either. You do not have to wait until the end of it. But as I say, that business case is really key when you're starting to prepare the initial steps for a redundancy situation and when you're planning for that. So Teresa, can you really run through other points that a business should consider when they're having that initial planning stage?
Yeah, what I would say is planning is absolutely key, because what is happening a lot of the time is that employers rush headlong into wanting to make redundancies, and what we need to make sure is that all the planning happens first, because then it runs much more smoothly if the employer is all prepared. So the way to do that is firstly to make sure that we've got a genuine redundancy reason. Now, I don't want to make this webinar too legalistic. You can always seek obviously our assistance if you need any additional information about whether redundancy is applicable. But as an overview, if you've got a reduced need for employees to carry out work of a particular kind, the kind that they're doing in the workplace, then you're going to be looking at a potential reorganisation stroke redundancy situation. So we need to make sure we've got that first. Then, as you say, the next thing is to prepare the business case. So as an employer, you need to be able to state in writing, 3 or 4 reasons for the need for the reduction. So are you saying it is because your business has been affected by COVID, for example, and your turnover has reduced? If so, by what percent? What do you anticipate it's going to be in the forthcoming period? You need to lay the foundations for why you've got the redundancy situation. You also need to be looking at the specific areas of the business that you want to make the reductions in. So to prepare, you need your business case. You also need to prepare in advance your at-risk of redundancy letters. The one thing about redundancy is have a look, see if you've got a redundancy policy or procedure, because, as I'm sure you're all aware, there isn't a statutory legal redundancy process that says it has to be followed. It's all down to case law. And what we've got to make sure is that people are seen and employers are seen to have an open mind when they are consulting with employees. So from the start, in the at-risk letter that needs to be prepared for each person and the announcement that's going to be made, they need to be drafted up, and they need to show that as an employer, you've got an open mind, that you're saying this is a proposal, that this is your draft of what you are anticipating in respect of a restructure. One thing I would say that's different about COVID times than previously is that it would be good in your business case to show as an employer that you actually have applied your mind to, could we just keep people on furlough? Would that mean that we didn't need to make redundancies? Another thing for preparation is it's good to do a timeline about when you're proposing to undertake these meetings. Make sure you look when your line managers are on holiday, when the employees might be on holiday, because that will affect timings. And you need to make sure your line managers are well prepared and prepped in advance, and they know what they are doing. Oliver, what does a fair selection process look like? Because that's when a lot of employers fall down in this area, isn't it?
It is. So you've established that you've got a fair redundancy situation and you need to make a reduction in terms of your workforce. What the business needs to consider now is really, well, what areas will that impact upon, and who should form part of those pools of employees that are at risk of redundancy. If, for example, you're no longer going to be carrying out business development, purely as an example, and you only have one person within that role, then that pool of selection is going to be the one person. They're in a unique role, so it's very much straightforward. The complications can potentially arise where you have a pool of individuals carrying out the same or similar work that you then need to all pull together to decide who will be made redundant from that pool. So you may be going again from a business development perspective, from a team of 5 down to a team of 3 or 2. But again, you need to apply some thinking and show your thought process, if challenged, on why people have been included within a pool or have not been included within the pool. Straightforward if everyone has the same job title doing the same work, but really look at what work they are carrying out in reality to determine if they should also be included within that pool in order to select who will be made redundant. Now, again, one question that we do get asked quite often is that, well, I've furloughed a number of people, there's obviously a reduction in work in that area. Can I just solely select those that have been furloughed for redundancy? And really, no, it wouldn't be safe to do that if you have people within the workplace that are continuing to do that work in the same or a similar role. The selection process initially that you made to decide who would be furloughed out of a team may not be safe to rely upon, but as everyone's doing the same job, you need to include them all within the same pool. Again, as Teresa mentioned earlier, there's this job retention bonus where if you do keep people in employment, you receive the £1,000 bonus at the end of January. And again, it may be the case that businesses are thinking about that and think, great, I can get that bonus. Therefore, I'm not in fact going to select those individuals for redundancy and make the others redundant within that pool. But again, it's not the sole criteria that you can use in order to select. What you need to consider is, A, once you've established the pool of people that are at risk, is how you are going to select from that pool. And the main way to do that is to use a selection matrix in order to score individuals on their ability to do the job. Now, with selection matrix, there's often a whole host of criteria that businesses look to use. But really, the main one that you need to be looking at is who has the best skills and ability to do the job that you need them to continue to do. And really, the weighting that you're applying to that matrix and the scores needs to be weighed in that favour. You want the best person to remain within the business to do that job, and that's ultimately what you are deciding. Other areas that you're probably going to look at as part of a matrix is any potential relevant experience or the qualifications that they may have, but also any disciplinary issues, attendance records. One query always with attendance records is actually, should you count them or not? If the absence is related to a disability, it could give rise to a disability discrimination claim. So potentially do not include those absences as part of the scoring, but give some thinking behind, well, really, how am I going to select the best people to do the job and to stay within the business moving forward? So I think that brings us on to our second poll, Teresa.
Yes, it does. So we're interested in your views on this, everyone. Oliver's explained to us all about doing the scoring. So are you obliged to disclose the scores of other colleagues in the pool to the employee provisionally selected for redundancy? So, you know, in Oliver's example of business development, if you were going down from 5 employees to 3 employees, the 2 that have been provisionally selected for redundancy, are you going to show them, do you think, the scores of the 3 people that came higher than them? So that's what this question is asking, and we're interested in your views on that. And then I'll give you the answer once we've had your thoughts. So sharing the poll results there, you'll see that 11% of you think you are obliged to disclose the scoring, 67% of you think not, and 22% of you are not sure. So a fair redundancy process, for that to happen, an individual has to have the ability, obviously, to challenge their own selection. So when somebody comes through and they are one of the provisionally lower scorers, when you send them the invite to their consultation meeting, you should also send with that letter all of their scores and obviously the criteria. If there are any management comments about those scores, against those scores, for the justification, that should all be sent to the employee in advance in readiness for their first consultation meeting with party their scoring. Now, in relation to scoring, Oliver, can I pass to you to ask about the volunteers for redundancy? It says that
you can,
I'm not sure
yeah.
whether.
Yeah, that's actually a lot clearer now when you've just said that as well. But yeah, absolutely. So one question as well is, do businesses actually have to ask for volunteers as part of a fair redundancy procedure and processes? No, there's no obligation on a business to ask for volunteers for redundancy, either at the very start of the redundancy process, during that, or otherwise. A key message is really, if you are asking for volunteers, reserve the right to make it clear that it doesn't guarantee that their application will be accepted. Reason for that is that you don't want to lose as a business those key individuals that have the experience that you want to retain, and also potentially those that are going to be expensive to make redundant. You don't want to be forking out high redundancy costs and notice periods if you don't want to lose them as well. Teresa, let's see if your sound has improved or not, and if not, I can pick it up. But one area that businesses are often perturbed by is collective consultation obligations, the dreaded phrase. But when do they kick in?
Okay, let me speak. Can anybody hear me?
That's
I can
clearer.
see you've all been putting stuff in chat. And so I'll just talk a minute, and yes, people are saying that's better. Goodness knows what's happened with my laptop, but shall I cover? Because lots of you said you couldn't hear any of my answer to the last bit. So, okay, let me just go over the last bit quickly, and then I'll talk about collective consultation. So I was talking about disclosing scores of colleagues in the pool to the employee selected for redundancy. And the brief answer to that, for those that couldn't hear me, is that you've got to obviously allow the employee to contest their own selection and look at their own scores, disclose to them with the invite letter the scores they've got, any comments from the managers, and justification. But you don't need to disclose to those employees provisionally selected the scores of the other employees at risk of redundancy in the pool. But it's normally helpful, after you've gone through the employees' scores with them, to tell them what the break point is, the mark they need to get in order to avoid selection for redundancy, particularly if they ask for it. So I'll now answer your second question, Oliver, about collective consultation, because this, as I'm sure you're all aware, means that if collective consultation is triggered, then there's a lot more obligations around consultation. So to be clear, if you propose as an employer to dismiss 20 or more employees at one establishment, now generally one establishment is one particular site. So if you're going to make 20 or more at that site, the only way it wouldn't be a site is if you've got two sites that are very geographically close together. And again, just seek our advice on that. If you think you're going to make 20 or more redundant within the next 90 days, then collective consultation kicks in, and you've got to consult with appropriate representatives of the affected employees. So that would be either trade union representatives if you recognise a union, or if you don't recognise a union, you need to appoint employee representatives. Now, if you've got between 20 and 99 employees within that one site within the 90 days, then you've got to consult for a minimum of 30 days before the first dismissal takes effect. If you've got 100 or more, it's 45 days minimum consultation. When I talked earlier about timelines, this is when the timeline really comes into play, because if you're going to need to have a ballot to vote for employee representatives, all of that has to happen before the first meeting with the employee representatives, and the consultation clock on the 30 or 45 days does not start ticking until that first meeting with the employee reps or trade union representatives. Oliver, are there any ways round collective consultation? Can an employer get out of doing it?
Fortunately, probably 99% of the time, there will not be a way around it, I'm afraid, is the bad news. There are limited exceptions to the collective consultation requirements, but that is only if the business can establish that there's a special circumstance which meant it wasn't reasonably practicable to go through the full collective consultation process with employees. Now, one that's often cited is insolvency, and whether that will be included in this special circumstance defence. But again, not necessarily, particularly where there's been a steady decline of the business and they could see that potentially it was heading towards that insolvency state. Realistically, a business can still place employees at risk of redundancy during that and carry out some, if not all, of the collective consultation. Really what case law has shown on this point is that there needs to be some kind of sudden disaster. So whether that's a physical disaster, some fire, some of the premises going, something along those lines, or really a sudden financial disaster, not a steady decline of the business where it's clear to see that the impact's going to be longer term. So the impact of coronavirus will not fall into that category in all likelihood, particularly because we've got the job retention scheme ongoing until the end of October that businesses can rely upon. So the message to people is maybe if business is in financial difficulty and trouble, seek advice, particularly in terms of the employment implications and the procedure to follow, because the defence may potentially work, but what the tribunals look at, what the court looks at, is, well, what procedure have you followed? So if you can at least carry out some procedure with your employees, it all helps establishing the defence and ultimately knocking down what the protective award is. So that's 90 days actual gross pay per employee if you fail to carry out a collective consultation process. That's the absolute maximum. If you can establish that you've carried out some, that 90 days is then gradually reduces that way. So really show that you are carrying out some of the procedure is the key point and takeaway from that. So one challenge that businesses are facing, Teresa, is, well, realistically, how can I carry out a consultation process when I have some people at work, I have some people working remotely, I have some on furlough? What advice have you got for those businesses?
Yes, it's challenging, isn't it? Because when we want to sort of launch a potential redundancy process, the best thing to do is to have a meeting with affected employees all together, and that simply is very difficult in these coronavirus times. So most employers have been using a video conference by way of Zoom, hopefully with the sound working properly, or Microsoft Teams, to try and facilitate proper consultation, but doing it in a safe way without the need for there to be big groups of people getting together. Now, the best thing to do is for you as HR individuals or people leading the business is to issue guidance to ensure those meetings are confidential, that any information that is highly confidential sent to encrypted to the personal email addresses of individuals, because many of them, if they're on furlough, their work system will have been cut off, so you'll be dealing with them by way of their personal email address. You as an employer need to make sure you've got a note taker present. What I wouldn't advocate is that you suddenly start recording via Zoom all the consultation meetings, because that's going to be very time consuming in getting those transcribed, and really all you need is the summary notes that you would have had in a pre-coronavirus time. So employers have been undertaking the group collective consultation meetings by way of Zoom and video conference facilities, and also the individual consultation meetings with the individual. That in itself throws up a bit of a problem, though, doesn't it, Oliver, in terms of the right to be accompanied at consultation meetings, because normally you perhaps have somebody, a colleague or the union rep, actually in the room, and if they wanted to have a break, in normal times, your manager would leave so that they could have a chat. You know, what's your view about being accompanied at redundancy consultation meetings?
Yes, the starting point really is there's actually no statutory right to be accompanied at redundancy consultation meetings. So we know that it applies to disciplinary grievance meetings, but it doesn't extend to redundancy consultation meetings. Now, often businesses offer the right to be accompanied as good practice and in the interests of fairness, particularly when you are reaching the point of the final meeting and you're looking at the dismissal meeting. If you do offer that right to be accompanied, again, you're going to have to make arrangements, whether it's remotely or, for example, if both people are face-to-face, for them to have a break, or, for example, where you are using Zoom, there's the function where you can have people in virtual breakout rooms, but really you're going to need to establish the ground rules on the accompaniment and how you're going to address breaks prior to actually carrying it out. So often have clients that put together an FAQ document that they issue to employees as part of the consultation process, and that question should be included within it. So with that in mind, in terms of potentially having the right to be accompanied at the final dismissal meeting, Teresa, what should businesses do and prepare for when they reach that final meeting?
Okay, so before that meeting has taken place, we need to, as the employer, have made sure you've complied, if necessary, with the collective consultation requirements, but on an individual basis, offered and had really a minimum of 2 individual consultation meetings with those provisionally selected. In terms of timescale, what often happens is that if there is no obligation to collectively consult, the employer wishes to get through the process as quickly as possible. And sometimes the employees push for that as well. They want it to be over as quickly as possible. But what I would say to all of you is, really, if you're not collectively consulting, you still need to have a redundancy process from the point of putting somebody at risk through to this final, let's say, dismissal meeting of a minimum of really 7 to 10 days. I would really urge you not to go anything less than that, and if possible, do a couple of weeks. So when the employee has raised various issues via the consultation meetings, best practice is to invite them to, as Oliver says, the sort of the final meeting, to feed back to them on any queries they have raised, to give them that right of accompaniment, and to then have a meeting, draw together any of the issues they have raised, give your justification to them in the meeting, and confirm their entitlements to redundancy and notice in that meeting, whether you want them to work that notice, whether they're going to be on furlough, for example, at the moment. And you then need to ensure, obviously, that you do your follow-up dismissal letter, which clearly sets out within that letter the justification for making that person's role redundant. Now, we want to engage you all on another legal question. So we're going to launch our 3rd poll of the webinar. So in that dismissal letter, when we are, as an employer, giving that dismissal letter, does an employee who is given notice have a legal right to an appeal against that dismissal? So I'll give you obviously a few seconds. So we've got a yes, no, or a not sure answer there in terms of, do they have a legal right to appeal? Well, we can see the votes coming in. So 78% of you think the employee has a legal right to appeal, 8% not sure, and 14% no. Well, the 14% of you that said no, strictly speaking, are correct, because there isn't a specific legal right to an appeal on redundancy. So as Oliver mentioned earlier, the ACAS Code of Practice does not actually apply to dismissals for redundancy, and within that Code of Practice, that is what specifies a right of appeal. But what we're therefore looking at is the case law. So the case law states that if you do not give somebody the right of appeal, that in itself will not make the dismissal for redundancy unfair. So it's not a fatal flaw. There's no legal right to an appeal. But it's one factor to be taken into account as to whether the whole process you've used as an employer is actually fair and reasonable. And so we would always urge you to offer a right of appeal. I'm dealing and assisting an employer at the moment, for example, and one of the complaints of the employee in their appeal letter is they feel that they haven't had a proper explanation about where their duties of their post that's being made redundant, are going, who's going to be covering the role, and whether they should have been in a wider pool for selection. So it's very helpful for us to be in a position where we've offered a right of appeal to that employee, so we can make sure a manager at a higher level can perhaps spend a little bit more time explaining that to the individual and obviously confirming that in the appeal outcome letter. Oliver, what is the employee entitled to if they are made redundant?
The employee's been with the business for 2 years. They've reached that 2-year service point. They're obviously entitled to the statutory redundancy payment. I won't go through the calculation because you're all no doubt fully aware of that. The current cap on gross weekly pay is £538 per week. Really, the areas that the business needs to consider on the entitlements upon redundancy are, well, firstly, what do you propose in terms of the notice period? Are you going to make a payment in lieu of notice? Do you have the contractual right to make that payment in lieu of notice as well? Are you going to ask the individual to work all or some of their notice period? Do they need to do a handover, for example? Do you need to keep them in the business for the notice period? And a lot will depend upon the length of the employees, the individual's notice period in terms of that as well. Or will the individual be furloughed for the notice period? Because as you will probably be aware by now, you can use the job retention scheme to claim back the 80% of the notice pay if they remain employed for that period, if they're furloughed for that period, under the terms of the job retention scheme. So that's areas that you need to think about in terms of the notice pay. And also, obviously with notice pay, if they are going to be furloughed, it's highly likely you're going to need them to top them up to 100% of their normal pay for their notice period, albeit you can claim back the 80% or whatever it may be moving further down the line in terms of what you can recover from the government under the job retention scheme. Another area that you need to think about is holiday as well. So the employee is obviously entitled to any accrued untaken holiday up to the date of termination. So that may be at the end of a lengthy notice period during which they may remain furloughed. Do you actually want to state that part of that is the holiday entitlement for the employee, or will you be making a payment in lieu of that at the end of the notice period? Now, again, you can't use the job retention scheme to cover any payments in lieu of notice, any payments in lieu of holiday entitlement, or any statutory redundancy payments. As we've advised clients, and it's now been categorically confirmed under the latest guidance on the job retention scheme, is that contractual notice will be covered by the job retention scheme, and meaning that you can claim that reimbursement. So if you have an employee that's been employed for 3 years, their statutory notice is 3 weeks, but the contract may say they're entitled to a month, 2 months, whatever it may be. You can still use the scheme, as long as they're furloughed, to reclaim that longer, the contractual notice period under it. So they're really the main considerations that you need to think about to include within the dismissal letter, and really the arrangements on the dismissal as well. So Teresa, really, what's the risk to the business if it all goes wrong?
Well, if it goes catastrophically wrong and you're supposed to collectively consult, as Oliver mentioned earlier, you're risking a protective award of up to 90 days gross pay uncapped per affected employee. So that's a massive hit. But aside from that, in sort of uncollective consultation issues, what the employee could do if they feel they've been unfairly selected for redundancy or they're not happy with the procedure that's been followed is they bring an unfair dismissal claim. So as an employer, going through the redundancy consultation process is a claim for unfair dismissal but unfair selection for redundancy. So you need, that's why we've shown you in terms of the steps that we followed, that if you've got a genuine redundancy situation, you could still end up with an unfair dismissal claim if you haven't followed this correct, fair and reasonable procedure. Now, all of the steps that are required in relation to that are, as we've said, fair selection, meaningful individual consultation, and considerations of alternatives to redundancy. So we're looking there at alternative employment. If someone comes back and says they want to take reduced hours and pay, making sure as an employer you've considered those. If somebody claims for unfair dismissal, you're potentially then exposing the business to a compensatory award in that they're saying, it shouldn't have been me, it should have been Joe Bloggs instead, I would have stayed employed, and therefore I'm entitled to my net monthly pay and benefits for a period of time until I manage to secure an alternative employment opportunity. The difficulty is obviously at this time there aren't that many jobs out there being advertised, and therefore people could be out of work for quite some considerable number of months before they're able to secure alternative employment, or indeed secure employment at a level reasonable to that which they were on previously. It may be that someone ends up taking a job, but they're earning a lot less. And if it's an unfair dismissal, you'll be paying the difference between their net salary with you in the redundant post and the net salary in the new job, stacking shelves, for example, in Sainsbury's. And therefore, that is why it's very important to get the process right. That said, an employment tribunal will not second guess what they won't say, oh, it definitely should have been Joe Bloggs, not you. What they're looking for is, have you used a fair and reasonable process? And as long as you have done that, then ultimately you should be in a position where you can successfully defend the claim for unfair dismissal. So Oliver, can you just summarise for everyone, really, what are the key tips that someone's got to make sure as an employer they do to avoid a claim for unfair dismissal?
Yes, just drawing on really the key points and messages that we've had during this webinar. Now, firstly, it's establish your clear, genuine redundancy situation. And as Teresa said right back at the beginning, the business case that you're providing to the employees and that are placed at risk of redundancy, so whether it's in a separate business case, it's within the letter itself, make it clear the rationale why that position and why you are making redundancies overall. Also, I've said it in previous webinars as well, think of a judge reading that business case, the at-risk letter. Is it clear to them? Now, it's going to be clear in your head because it's your business. You are aware of everything. You have that knowledge. Think of a third party reading it, and will it be clear to them that you have established a genuine redundancy reason? That's the first stage. Second stage, as Teresa again said, the consultation and the process that you follow is the second or the most important thing as well. So if you're under collective consultation requirements, you're going to be consulting with trade union representatives or employee elected representatives as well. Or you may recognise a trade union anyway as part of the collective agreement, that even if you're not under formal collective consultation requirements, you may still need to speak to them and involve them within the process itself. So I will say agree a timetable as well with whether it's the trade union rep or the employee representative. So everybody is clear from the very start at the outset what you're going to be doing, when you're going to be doing it, and then it builds in time to ensure that you can establish that a fair, proper, reasonable consultation process has been carried out in terms of the proposal. Thirdly, use of technology is ever so important now, whether that's Zoom, Teams, Skype, whatever you are using. Make sure the employees, again, their representatives, anyone that accompanies them, ensure they all know how to use it and what the proper rules are in terms of the meetings taking place as well. Fourthly, in terms of the selection process, get that matrix agreed at an early stage as well. So that's the method that you're potentially going to be selecting people for redundancy, and that's going to be a key part of the evidence if you're going to come before an employment tribunal when they're looking at establishing why you as a business selected Mr. Bloggs over Mrs. Bloggs. So get that matrix agreed and ensure that it contains the objective justification that you can evidence and back up why the individual has scored what they have scored. The next stage is consider alternative employment, alternative positions. So whether that's within the business or maybe a group company as well, or even at a different site if you have one. Look at all potential alternative vacancies and put all of those to those that are at risk and going to be made redundant, even if you know that they will not be interested, or maybe even if you know they don't have the relevant experience or qualifications to do it. Again, it's part of a full, thorough, proper, open, transparent consultation process that you're following in order to establish that fair procedure that we spoke about. Finally, as Teresa said, make that dismissal letter tailored to the individual to establish why they're being made redundant, and also covering off anything that they've raised as part of the consultation process. So ordinarily, an employee needs 2 years service to bring a claim for unfair dismissal. That doesn't apply to anybody that you've potentially selected on discriminatory grounds. So anyone with a discrimination claim, bear that in mind. And also potentially if they were selected for an automatically unfair reason. So that at the moment may come into play where an individual's saying that they don't feel safe, that the health and safety is compromised by potentially coming back to work. If they're selected because of that, it's potentially a claim for an automatic unfair dismissal where that 2 year period doesn't count. So again, that may be a relevant area as you're slowly reintegrating people back into the workplace.
Great. So now we're over to you for questions, everyone. So if you want to ask a question, we'd rather you put it in the Q&A area than the chat, because it's very difficult to keep up with the chat, and we may miss them. So if you just type them in the Q&A area, don't worry, we're not panning to you live. You can be anonymous if you want, but it would be good if you put your question in the Q&A. What I will do is be in a position where I will pick up a couple that have come from the chat area. Sheena asked a question in the chat about the £1,000 job retention scheme bonus, saying she plans to bring them back on the 1st of August, pay them more than the minimum and keep them on permanently till at least January. She's asking, Oliver, will she be able to claim the, she's missed a zero off there, £1,000 bonus in January, please?
They're the essential requirements that we're aware of currently. Unless I've missed it, I don't think that we've actually received more detailed guidance from the Chancellor as of yet on how this retention bonus is going to work. So the finer detail of it, he did promise us that it would be by the end of July. So as usual with the job retention updates, I imagine it'll be after 5 o'clock tomorrow that we will actually get the definitive detail and the rules behind the job retention bonus. But everything that you've put within your question ticks the current criteria as we know it.
Yes. We've got a question. What is your view on using interviews as a selection process when there is no real documentation to use for the matrix type approach? Oliver, do you want to take that one, and then I'll take the next?
Yeah, so interview process can be the most relevant way in order to select an individual. You're not bound to follow and use a selection matrix in order to have the selection, particularly where it may be a scenario where two people are doing the same role at the moment, but you're saying that we no longer require those positions, but we were going to create a new position, which is potentially similar or not too far off what it was. But you actually want to interview both candidates for that newly created role and position. And in that case, an interview is potentially the best selection method in order to decide who is who's best to do that role. But again, keep the evidence on why you have selected that individual, on who was successful as part of the interview process, because you'll probably be doing scoring as part of that when you're going through the job description on deciding who has the best skills, experience to do that role. So you'll still be explaining why the unsuccessful candidate was unsuccessful and therefore why they are being made redundant. But yes, you can use an interview process.
Yeah, I mean, competency-based interviews are the best to use. I do have one employer, rather large employer in the UK, who uses both a matrix and interviews for their selection. I must admit, it's very resource heavy to do that, and time consuming, but yeah, as Oliver said, there's no reason not to do it. Next question that I'll take is, can we offer reduced hours as an alternative to redundancy? Absolutely, you can. So before you kick off with your redundancy process, you can consider, when you're putting your business case together, any alternative to redundancies, and take those into account. What you might want to do, you need to decide whether you're going to put people at risk of redundancy and then consult with them as part of the process about reduced hours or days, etc. Or whether you want to approach them first and see if you can sell the idea to them of reduced hours, so that you don't even need to enter into the redundancy consultation with them. Effectively, you're consulting with them about a reduction in hours rather than a redundancy. So that can be done either way round, but consultation needs to take place whichever way you decide to undertake that. And certainly, my experience is that quite a lot of employees in their consultation meetings will put forward reduced hours if they really want to keep their job, particularly in these furlough times where they think that maybe things might improve in the months to come, so that they are hoping that it's going to be a sort of temporary reduction in hours as opposed to a redundancy. That one, we have one in the chat, I think. Oliver, I don't know whether you've seen it. It says, we have one employee who is at risk of redundancy. Normal process is to have a protected conversation with individuals to propose an enhanced redundancy payment on the proviso that they sign a settlement agreement. If they don't agree, we would go into consultation with them. Do you see any issues with this?
It happens quite a lot, with settlement agreements being offered to those at risk and then enhancement being made as the consideration for accepting that agreement and the money side of it. So not an issue itself, because it can be quite commonplace, particularly where you think there's a risk to the business in that redundancy or dismissal of that particular individual. So whether there's any discriminatory factors that are in place, or you think there's maybe an issue overall with the process or the actual redundancy reason, or if you want to select somebody that's within a pool and not follow a full process as well, so to pick somebody from that pool. 99% of the time, it's all about the negotiation and agreeing the financial amount with the employee. That's the biggest thing. It rarely gets messy. It only gets messy when you have protracted negotiations over the financial amount and the figure that then fall apart at some stage, and you then have to fall back upon the consultation. So they're going to be alleging, well, it's always been the intention to get rid of me and make me redundant throughout, which yes, it is, but you've put them at risk of redundancy already. But it does potentially make the situation more contentious, shall we say. But yeah, as an approach, there's nothing wrong with it, and it's commonplace.
Indeed, it's just going to cost you more money because you're having to enhance by way of a settlement agreement. If you think you've got a robust reason for the role to go, then why pay more than the statutory and the notice entitlement, unless you've got a really sound business reason for doing that? You're spending out more money. We've had a question about that I'll take on, what are your views on insisting employees take accrued annual leave during the notice period rather than paying it in lieu of the final pay? Well, my view is that as an employer, it's absolutely commercially sensible to do that, to be telling the employee to take their accrued annual leave during that notice period. The only reason you wouldn't want to do that, I would say, is if you need that individual to work the entirety of their notice period. Now, if you need them that badly, I would query why you are making them redundant, unless they're perhaps doing holiday cover for other employees. But as provided you don't need them working, absolutely, in your notice letter, in that final letter to them, confirm that you require them to take their holiday in the notice period, and then in effect you're not having to fund further payments over and above that.
Yeah, the only thing that I'd add to that is that, yes, legally you can do it, and you can give the required notice so that they do take any holiday during particularly a longer notice period as well. So legally, you're absolutely fine with doing it. Some people feel uncomfortable, or the employee challenges it on the basis of fairness. I don't think it's fair or ethical almost, but from a legal position, you're categorically fine in doing that.
I don't think we've got any more questions. Fire away, anyone, if you have. By all means, type them in the chat or the Q&A. But if you haven't got any further questions, we will bring the webinar to a close. Is there anything else, Oliver, that you want to pick up on that you think that we haven't covered, or any areas? Leslie has put something in the chat about the HR1 form to the government with the collective consultation, which, yes, you need to make sure that you do that if the collective consultation requirements kick in, to make sure you don't get a fine from them as well as the protective award.
Yes, the only thing that I'll really add is that obviously we know that the support from the government under the job retention scheme is reducing from a financial sense up until it concludes at the end of October. So the sooner that you can start planning as a business on how that's going to impact your workforce, the number of employees, the better, and always seek advice.
That's great. Well, thank you everyone for joining us this afternoon. Sorry about the slight sound issues at some point, and hopefully we will see you all at our next webinar. We'll send the